I'm Brett.
And I'm Alice.
And we are the prosecutors. Today on The Prosecutors, we respond to more of your questions and comments about Maura Murray and wonder, will the madness ever end? Hello, everybody, and welcome to this episode of The Prosecutors. I'm Brett, and I'm joined, as always, by Alice. Hello, Alice.
Hey, Brett. How you doing?
Doing well. How's that microphone doing?
Oh, well, we'll see, everybody. I'm just really technologically unsavvy, so sorry if the sound is off, everybody.
Yeah, you may have noticed the sound was a little weird in yesterday's show. We're not sure why this happened, but Alice's new microphone, which has been performing beautifully, all of a sudden was incredibly loud, and getting it where it wasn't loud has been a challenge, but we think we've accomplished that, so we'll see how things go.
And the reality is I am just a loud person in general, so maybe the microphone was revolting and saying, you know what, I'm just going to make you sound the way you normally sound.
I think that's probably right. You were misleading the audience, and now they know. Now they know the truth.
I only sound calm, cool, and collected when you can edit me.
Exactly. It's funny, when you're doing the editing, when you're editing yourself and other people, you do pick up on all these weird things that you do when you're talking. It's an interesting experience editing your own podcast. But well, everyone, today is our second follow-up on Maura Murray. This should be our last Maura Murray episode. Let's pray.
I think someone accused us on Twitter of being obsessed. I think or addicted, I'm sorry, that we're addicted. I think the case is addicted to us.
Exactly. And I feel like the case is just getting crazier. I don't know if we're bad luck or what, but just in the last couple days, I mean, the Twitters have been on fire with Maura Murray. I don't know if you guys out there in listening world have been paying attention, but it's been something else. But before we get into that,
I was going to say, go on, Brett. Don't leave the audience hanging. What is the something else you're speaking of?
Before we get into that, let's talk about Missy Bevers. Because Missy Bevers, we did an episode on her in between Maura Murray and our follow-up episodes. And
can I say thank you guys for continuing to listen after Maura Murray. We really appreciate it.
Yeah, we wondered if our listening would go down to 10 downloads or something after the Maura Murray explosion. So glad you guys didn't abandon us. And in fact, some of you reached out, had some thoughts, some questions, some follow-ups. So we wanted to run through that real fast. We'll start with, I guess, sort of a controversial thing. We had a couple people who reached out to us, most of them very respectfully, about Missy's personal life, I guess is a good way to put it. You may have noticed we did not focus on that very much in our discussion of the case. Those of you who follow it closely know that her personal life has been the source of a lot of gossip and speculation since her murder. We had one person who, frankly, was angry that we did not talk more about that and about whether she may or may not have had an affair or whether or not she was having improper communications with other people, that sort of thing. And at the end of the day, we made a conscious decision. It is not clear to us, and I think there's no evidence that any of that has anything to do with her murder and who killed her. And I think if it did, it's been 4 years. A lot of it's tied to communications online. The police, if that person or those people or whatever were involved in her murder, I think you can feel pretty confident that the police would have identified a suspect by now. So we had to make a decision. Are we going to talk about this stuff? Are we going to dive into this stuff or not? And at the end of the day, Missy is a murder victim. We have a lot of respect for victims here. We're not, we're not holier than thou. We get it. True crime. It can be voyeuristic. It's entertainment that involves misery for others. We totally get that. But when it comes to this kind of stuff, and when it comes to victims, and when it comes to potentially shaming victims, if we can avoid that, we're going to avoid it. And this was a case where we felt like we could and we should.
And here's another thing, in researching the case before we actually recorded that episode, we looked for all angles, including whether there was any meat to these allegations of extramarital affairs, and we did not find any hard evidence that met, any sort of evidentiary standard. And that's why we decided that there was not enough to go on in order to present it as a potential theory. And this is a little bit of a teaser. I know we mentioned in a previous episode that we joked if you guys wanted an episode on 404B, rule of evidence, to let us know. And we actually got a lot of responses to that shout out. A lot of people said, yes, I would love an episode where you talk about 404B, rule of evidence, about letting in relevant conduct, that includes kind of extramarital affairs, previous bad conduct, those sorts of things, when it's allowed into court and when it's not. And based on what we could find evidentiarily for Missy Bevers, this type of hearsay, and really I think it's like one hearsay, so I think someone just kind of raised it about the extramarital affairs, would not, make it into court. We would not be able to make that sort of argument as prosecutors, or if I were defense counsel, to bring in that type of, supposed evidence.
And we know, there's something to be said for completeness, and there's something to be said for exploring every angle of every case. But as we've said before, these are real people's lives. Missy was the mother of children, and she's a murder victim. If there's no need to go into it, we're not going to go into it. So totally get that some people don't like that, but that's just how we're going to do it here when we talk about these cases. So another thing on Missy Bevers, we had someone reach out to us on Facebook who is from Texas. They've done a lot of research in this case, and they had some interesting additional things that we had not necessarily heard. And so I'm just going to read you. I'm not going to read you all of them because they wrote a really thorough few comments. You can see them all on the Facebook page at Prosecutors Pod on Facebook. One, they point out that the door that they tried to sort of pry open in that really awkward sequence with the hammer and the crowbar is not actually into a room. It's a utility closet with a closet-sized door rather than a regular room door. Basically, they think that they may have figured that out, and that's why it looks like they're so lazy in the way they're trying to open that door. They sort of realized, hey, there's not going to be anything worth anything behind this door, so they just sort of abandoned it. They talk about when this person is sort of shattering glass, and they point out that glass, when you shatter it, it breaks into sort of small pieces, the little popcorn pieces, and it's safety glass, and so this person could just be sort of avoiding that, and that's why they look so lackadaisical in how they're doing that. It's really just to protect themselves. I thought that was interesting.
I will say, I think in our first episode, we noted that we always love hearing your thoughts on our theories. And we did actually have another prosecutor in the area where Missy Bevers' case takes place, who full-throatedly agreed that it looked like basically someone who was on drugs, on some sort of a trip, and it was a robbery gone wrong. So I'm just going to throw that out there as someone else who prosecutes these types of cases in this area, has experience in this and actually agreed before we espoused our theories.
It's nice to have someone agree with you every now and then. A couple other things from Facebook, and the individual's named Tim Coville, who was commenting. I want to give him a shout out. He points out that the police did not release the video from the tactical goods store. They actually just released a still shot, and then the store itself released the whole video. No idea why the police held that back. Don't know how significant it is that they did. They did release the still shot, so I think the fact that they think they're related stands. Really interesting thing. Well, first of all, before I get to the really interesting thing, I'll say that one to the end. Tim tells us that they actually did a lot of work to try and figure out how tall this person was. Basically, they did a forensic video reconstruction. They used a lot of different facts about the building and the angle of the cameras and that sort of thing. We talked about that, how cameras can be deceiving. I mean, I think this police department did a really good job on this case, and this is an example of that. Like, it's interesting. The Texas Code says that the handle on the fire extinguisher box has to be at least 48 inches from the floor, and the top of the box is 60 inches. That's really interesting. And so they use that fact to compare where the killer was standing to get their, speculation about how tall this person was, and confirm that they probably are quite short. So for those of you who are in the "it's a woman" camp, they're obviously short men, but maybe that means it's a little bit more likely that it's a woman. And then the last thing, and this was really interesting, and I'm going to have Alice talk about geofence search warrants here in a second, but there was a geofence warrant, and in the affidavit to that warrant, it notes that the church's cameras were activated at 2:23 a.m. They didn't show anything, but something activated those cameras, and that is only about 20 minutes after the vehicle left the tactical goods store. And Alice had speculated that this person sort of drove over to the church, and then in the church parking lot might have taken some drugs or whatnot, and then later on went into the church. And I think, we don't know for certain because we don't have anybody on video, but I think that's a pretty interesting piece of evidence, and I think indicates that Alice, as usual, is probably right about that.
That's kind of you to say. Brett just mentioned the geofencing. For those of you who may not know, geofencing is basically what it sounds like. It's a virtual geographic boundary, and oftentimes when you're looking at geofencing, a lot of these warrants, I think, look to Google, because as you may know, Google is very prolific. They offer lots of apps that run on all types of operating devices. So not just iPhones, but also Androids and many other smartphones. And basically what happens is, this is no surprise to anyone, Google tracks a lot of information about their users, including if you have your GPS locator on your phones. And every phone is different, but I think at least my phone, when you download an app, it asks you if you want GPS to be running on it. It's like only once, never when using the app. And if it's turned on always, then the cell towers basically can ping your phone and know where you are repeatedly. So if you can imagine, you're this light lighting up each time the cell towers ping you, and as you're moving, it kind of creates this map of where you are or where you're going. And you can imagine, if you're in one place for a long time, over, say, an hour or two, your phone or the GPS on your phone will be pinged repeatedly in that area, and that's kind of the fence that this virtual fencing is doing. It's creating a fence around where you are so that the law enforcement can see who was in this area for how long. And it can be very helpful when you have no other leads, because you're given phone numbers and you're given identifying information about the app that was being used. Now, it's not perfect, because obviously you can give fake information when you download these apps. But for any of you who've downloaded apps, you probably remember, you probably have to sign in with like some sort of Apple password, or you usually have to give some sort of recovery email or phone number. And those are typically linked to some other identifying information. So that might be too much information for all of you, but it's an interesting way to know how, basically private companies who are tracking your information can be helpful in a criminal investigation.
Yeah, it's remarkable how many tools law enforcement has these days in cases like this. And I don't know what that says about the fact that they used those tools and still have not found out who killed Missy. I don't know if it means this person was a very sophisticated killer, or, like we were speculating, they're somebody who, they're on drugs or whatnot, and maybe they didn't have the phone with all the sophisticated apps.
Well, you're right about that. I mean, there's a few possibilities, right? This person could have left their phone in the car or at home, knowing that they can be tracked, or they've turned off all of the locating devices on their phone in anticipation, or they could have deleted all of it before the information was turned over to law enforcement. So, it's not a perfect law enforcement tool, but this person may have known what they were doing, or they just, forgot their phone somewhere.
So that's everything on Missy Bevers. Hope you guys enjoyed that episode. Thanks for all the good feedback. Thanks for the continued support. Now let's move on to Maura Murray. So today's episode, we talked about this a little bit yesterday, is mostly going to be kind of legal nerd stuff. But before we get to that, we have to talk at least a little bit about the recent drama in the community. Yesterday I said something about how it'd be nice if everybody could just get along and work together. Well, that's just not going to happen. So I'm just giving up that dream. That's not going to happen.
How naive were we?
I know. So naive.
I can't believe we actually said that yesterday. Of course we say that, and then, we're told to eat our words.
So, yeah. I mean, look, we still like everybody, but it's obvious they don't like each other, and they never are, and that's fine. One interesting thing we want to talk about, we recorded this episode a little bit late, and I guess it's good because I feel like in a case that's kind of old and been kind of stale, there's all these new developments recently. James Renner reported actually earlier today that Billy Roush had discovered that Maura was cheating on him the night before she disappeared. Well, he discovered that the day before she disappeared. You may recall this is the day where Bill was on the phone with Kate and attempted to call Maura several times, and they never connected. James we're not exactly sure how he knows this. He basically has a source, apparently, who says, and I'll give you the quote from his website. Essentially, Maura and Bill shared a phone line. They were both on the same cell phone plan. And apparently, and I don't know how this is possible, certainly not possible with my current phone, I don't think, maybe it is, Bill could listen to Maura's messages. And this is the quote that James Renner has posted on his website. There was a message from Kate, and it says, the story, according to Bill, with information from Kate, is that Saturday, after they dropped off Fred, remember this is the night of the mysterious party when Maura wrecked her car, they were out together, the girls went out. Kate and Maura had some drinks. Kate is saying they met 3 new guys who did not go to UMass and were from out of the area. Apparently, they were all talking. Then at one point, Maura and one of the guys were gone. Bill asked Kate about this because one of Maura's voicemails was from Kate, asking what was up with Bill and what happened with that guy the other night. Apparently, Missing Maura Murray, the podcast, Lance and Tim's podcast, is going to talk about this more tomorrow. So on Thursday's episode, I can't wait to hear what they have to say. As we said yesterday, we talked to Bill. Bill has told us, and he's told others, that to the extent Maura was cheating on him, he learned about that after she disappeared. So I don't know whether this is accurate. You can imagine it answering some of the questions that we raised yesterday about why Maura was so upset, and even why she might have needed to sort of get away for a little while. So I don't know what your thoughts are on that, Alice.
This is heated. My thoughts are this is heated, and there's a lot more that will come out after we record this podcast. So I hate commenting on imperfect information.
Yeah.
I'm being cautious right now, if you can't tell.
I don't know, guys. I don't know. I don't know how much any of this has to do with Maura's disappearance. I mean, that's been the thing about the online community and the fighting and the gossip and everything else for a while. As I've said, I've made no bones about the fact I'm a big fan of James Renner, and I am, and I think he's brought a lot to this case, and I think he's uncovered a lot of stuff. His fighting with Aaron I don't know how productive it is. And I'm not blaming him. I'm not blaming her. I think there's plenty of blame to go around. He often refers to Aaron as a representative of the Murray family. I don't think that's accurate. I mean, yes, she gets information from the Murrays. Our feeling after talking to Julie was Julie will do anything to find her sister, and she'll work with anybody to find her sister. And she's not that concerned about what I think or what James thinks or what anybody else thinks. about these folks, and she's not that interested in sort of weighing in on any of the crazy, stupid things they do or say. James wants the Murray family to disavow them. I don't really know what the purpose of that is. I mean,
just based on our conversation with Julie, I think there's nothing to disavow from her point of view, because she was clear with us that no one speaks for the Murray family except for the Murrays, and I respect that.
Right, exactly. And if Aaron says something dumb, I don't know what good it does for Julie, who's focused on finding her sister, to run out and say, I disavow. I don't know what sort of cosmic balance is put back in place by Julie or the Murray family doing something like that.
And like Julie mentioned to us, it's a full-time job to correct all the inaccuracies. And again, I empathize with her. She's just focused on finding her sister.
Right. So at the end of the day, I like drama. I grew up watching Days of Our Lives. I'm into that kind of thing. Not really anymore. But
you were a kid who watched Days of Our Lives?
Absolutely. Man. That's when Days of Our Lives
that's another
was
conversation
good.
for another day.
Marlena was possessed by the devil. You remember that? That was awesome. Anyway.
No, of course I don't remember that. I didn't watch Days of Our Lives as a child.
Anyway, so the point being, we all enjoy drama, and that's great, but I just don't think it has anything to do with this case. This is completely separate as far as I'm concerned. So maybe eventually, it'll come out that Bill murdered Maura. Could happen, I guess, and it'll all tie back to this, and James will get a Pulitzer or something. If it's true, he deserves one, because he'll be the one who uncovers it. But if what you're really worried about is finding Maura, I just don't know. It's kind of overwhelming, frankly. I just didn't know how bad things had gotten until we got involved in all this. So, I mean, bless you guys who do Maura Murray all the time, because this has to be exhausting. Anyway, so let's talk about the law. Legal nerd time. So if you're not a legal nerd, you should listen anyway, because it might be interesting. 3 things we're going to talk about today. We're going to talk about grand juries, we're going to talk about defamation, and we're going to talk about FOIA. We'll start with grand juries. There's been a lot of talk in this case about whether or not there was a grand jury involved, and people put a lot of stock in this. Some people think if there was a grand jury, that means the police, they had a definitive suspect, and they were really going after that person, and they just didn't have enough evidence. And man, wouldn't it be great if we just knew who that suspect was? And look, that's possible. Grand jury secrecy is a big deal. Grand juries, by their very nature, are bringing in a lot of information and people being accused of crimes. And sometimes at the end of that grand jury, you realize there is no crime here, or that person was innocent. And so we don't want people to be tarred with stuff that happens in a grand jury, and then no criminal action comes about. So grand jury secrecy, there's a law in every state. There's a federal grand jury secrecy law. It's very serious. It's sacrosanct in a lot of ways.
Brett, before we get too far, can you maybe explain to people who aren't familiar with what grand jury actually is?
Sure.
Because you're right. I think a lot of people think a grand jury is just you come in and you say, indict this person. But a grand jury is actually much more than that.
Right. And that's a really good point. So you have in the law something you call grand juries, and then you have petite juries. Petite juries are what you think of as the jury. 12 people who hear a case, hear a trial, and decide whether someone is guilty or innocent. In the United States, a legacy from our common law ancestors, you have, before you can bring an action, especially in federal court, but also in most states, you have the right to have the grand jury decide whether or not to return an indictment. So basically, prosecutors go in to the grand jury. It's just the prosecution. The defense is not there. Often the defense doesn't even know there is a grand jury because there's not really a defense yet in a lot of cases. The prosecution puts on its evidence. It puts on whatever witnesses it wants to put on. And then at the conclusion of that, the grand jury decides whether or not they want to return an indictment. And it's a much lower standard than at trial. At trial, you have to prove something beyond a reasonable doubt. don't have to do that at a grand jury. You just have to show, what's the standard, Alice?
Probable
You just have to
cause.
show probable cause that a crime has been committed. And that's one reason some people occasionally will mock grand juries and say, you could indict a ham sandwich because probable cause is a very low standard. But you at least have to show that. And it's a good opportunity as a prosecutor to really look at your case and think about whether you have enough to go forward. Because if you have doubts about whether or not you can get an indictment, then you certainly should have doubts about whether or not you should be going to trial in that case. So that's one function of the grand jury, and that's the function that people know about the most. But there's another way that grand juries are used, and that's for investigation. And that's when you might not even know if a crime has been committed. You might not have any suspects at all. But what you can do is you can use the grand jury to do things like issue subpoenas. So you go in, you talk to the grand jury. Actually, don't even have to talk to the grand jury, but you issue a subpoena looking for records under the authority of the grand jury, and it's a way to gather evidence. Another thing you can do is you can have witnesses come in, and they're under oath, and so they have to tell the truth, just like if they were in trial, and you see what kind of testimony they have and what sort of information they have. And this information gathering process it might lead you to a crime, or it might lead you to believe that no crime has been committed.
And the interesting thing about this is a lot of people, I think that prosecutors act by themselves. They want to do whatever they want. They get this power trip, but really there's actually a grand jury to go through in a lot of the investigative process as well. So that might be new information for some people. And one other difference I wanted to note from the grand jury versus the petite jury, you may know from watching movies or TVs that the lawyers and the witnesses don't ever speak to the petite jury. There's kind of this wall with them. The judge can speak with the jury, but that's it. And that's to keep any sort of sway outside of the court from happening, right? You don't want some witness or some lawyer talking to a juror at the water fountain and giving them some information that's not actually presented in court and can be rebutted by the other side. But the grand jury, because it's only the prosecution and the grand jury, they can actually have a conversation with the witness and also with the prosecutor and ask questions about the case, both about law and fact. So there's actually more of a dialogue in that instance. And I note that because I've had friends who've served on petite juries who are frustrated. They're like, I wanted to ask so many questions, but I can't. And there's a method of asking questions if you really do have a question, but it has to go through the court in a petite jury. But that sort of wall doesn't exist for the grand jury.
And it's a really interesting bulwark. I mean, there's so many things that we do in this country, so many different ways we balance power and prevent all-powerful, distant government from doing everything. And that it is interesting because the grand jury is this sort of community link to the prosecutor's office where you are sort of, in a way, kind of working together on these cases to determine whether or not there's anything worth doing, but also acting as a check on the prosecutors. If it is truly a frivolous prosecution or a prosecution that is purely to antagonize someone, it's a nice check that you have. And Alice is right. I mean, you do have this back and forth, and grand jurors will ask you questions about the law, and they'll challenge you on that, and they can ask questions of the witness that they want to know about the facts. So they're not passive, and they're not just sort of sitting back weighing evidence or whatnot. They're actually sort of really engaged in the process. And I think, if you ever have the opportunity to be on a grand jury, you should do it. I don't know anybody who's done it who didn't enjoy it. It's just different in a lot of ways from serving on a petite jury. I mean, of course, I would love to do that too as a lawyer, to sort of see that from that side. But I know a lot of people hate jury duty. I think grand jury is a little different.
I think grand jury would be fascinating.
Yeah, I do too. And all that to say, there may have been, in fact, it seems there were grand juries in this case. That does not mean that there's a suspect. It doesn't mean that the prosecution had narrowed things down to a single person. They may not. We won't know just in the grand jury because, like I said, grand jury secrecy. But to the extent people thought or think that, well, if there was a grand jury, then they're really close to a criminal indictment, or they really believe Maura was murdered, or they must have evidence of that, that is not necessarily the case.
And to the contrary, almost every investigation uses the grand jury for the investigative phase, and certainly not every investigation results in an indictment or a prosecution.
Right. And I've read a couple places, people say things like in New Hampshire, they don't use grand juries for investigative purposes as much. I mean, I don't know that. If you practice in New Hampshire and you want to let us know, let us know. But even if that were true, the Maura Murray case is extraordinary. So I can imagine using the grand jury in that way. In this case, even if they don't typically use a grand jury in that way. So that's grand juries. Let us know if you have any more questions about that. We can follow up on that
was a
later.
really good question for the person who asked about it.
Yes, thank you for that. So let's talk about defamation. We talked about that briefly. We mentioned Erin Larkin's podcast where she talks to Guy Parody, who is a private investigator who is not associated with the family. And I had said rather flippantly, frankly, that it's like a law school exam question on slander. So I went back and I listened to it again because I was curious about whether or not I was right about that. And I got to say, I don't know that my opinion changed much, but I'm going to walk you through this and sort of how this works and what I think's really going on in that episode and a couple other things. So number one, let's just talk about the elements here. So you have defamation, which is usually divided up into two kinds, libel and slander. One is in print, the other is over the airwaves or on a podcast. But we'll just call it defamation because it's basically all the same. So here are the elements you have to have. You got to have a false statement purporting to be a fact. So you may have heard that truth is a defense in slander, and that's absolutely right. If you state something that's true, then you're golden. If what you're really doing is just saying your opinion, you may be golden. But if you have a false statement that purports to be a fact, that's a problem. Second part is publication or communication of that statement to a third person. So you can hold whatever views you want to have, but once you publish those views, that's when it becomes problematic. You have to have fault amounting to at least negligence, and we'll talk about what that means in a second. But if this is an accident, you're not necessarily going to have trouble. But if you do it on purpose, or if you should have known better, that's when you have an issue. And then you have to have damages, which you have to have in any tort, though defamation is kind of funny in that you can have these circumstances where it's defamation per se, and you don't have to prove damages. When you have that, it means damages are assumed. And it's kind of funny, the things that are defamation per se, like bringing a woman's honor into disrepute is defamation per se. But another one, and a far more common one, is saying that someone committed a crime. So if you accuse someone of a crime, and if you make factual statements that they committed a crime and you're wrong, then you're going to be in trouble when it comes to defamation. Now, there is...
What if you're right?
Well, if you're right, well, then once again, truth's the defense. So you're fine then. One thing that affects this is the Constitution. So the Constitution provides us a lot of protection when it comes to what we say and what we publish that people don't necessarily have in other countries. In Britain, for instance, you have defamation cases all the time. I don't know how they have any newspapers that are still in business, but in the United States, if it's a public person or if it's an issue of public discussion, then you have a much higher standard you have to meet. You basically have to show actual malice or reckless disregard for the truth. So you've got to really you're trying to say a lie about somebody, and you want to hurt them and you want to damage them using this lie, and proving that is pretty tough. You may have heard of the case New York Times versus Sullivan. This is like the seminal case in defamation law, and it talks about that sort of high standard you have to have for a matter of public interest. Now, look, we talked about Rick Forcier. That was what this was all about. Rick Forcier, I don't think is a public person in any definition. But Maura Murray and the Maura Murray case is obviously an issue of public discussion. It's an issue of public interest. And I think because of that, your case would be a little bit more difficult to prove. Whether a guy crosses that line, though, if you listen to that interview, there are things he says which are demonstrably false. And he had to have known they were false. And that's what really bothers me about that interview. And if you listen to it, just when you're listening to the interview, listen for when he says things that aren't his opinion. It's one thing to say, I think Rick Forcier had something to do with this. It's another thing to express that opinion and then use a false fact to support it. So if you say that and then you say, and I know he did because he told the police or he told the press that she stopped by his trailer wanting to have sex with him, that is a lie. That never happened. And if he's saying that one of those people told him that and that's how he knows it's a fact and they didn't tell him, there you go. I mean, there's your case. And there are other things he says throughout that interview that I think are problematic. So James Renner has called upon Aaron Larkin several times to take that episode down. I don't know that I would go that far. It seems like, I don't like censorship. I don't like the idea of sort of taking stuff off the public airwaves. And I think that's particularly true in this case just because so many people have aired Guy Parody's theories on this. And so many people have talked about Rick Forcier and their theories about him that I don't know that you can really just narrow this down to Aaron Larkin and her podcast. And arguably, that also plays a role. There's this sort of notion of sleeping on your rights, that if this is happening and you're kind of letting it happen at some point, you can't really just, go after one person and say, well, everybody else is saying this, but I want to sue you. So I don't know. I think it's a crazy interview. It's insane. And a lot of the stuff he says is just, one of the things he says in that interview, we'll just kind of veer off topic real quick, but this is still legal, is that, and I don't think we talked about this yesterday, Alice, correct me if we did, but at one point he says that he was able to get a search warrant based on an anonymous caller told him that an individual was selling drugs out of their car at a school. And based on that, he was able to get a search warrant for this person's house.
No way, no how.
No way. No way. That's insane. It's just
that could have been one of the factors of many other things, but that alone would not,
right.
Satisfy probable cause to get a warrant.
And you can, just sitting there out in radio land without a law degree, you can imagine why. Number one, we have no idea whether or not this anonymous caller is trustworthy. Number two, they're not saying he's selling drugs out of his house. So why are you getting to search his house? It's purely speculative. There's no way you could get a warrant. And if you could get a warrant on that basis, then the Fourth Amendment means nothing. Another thing he says is that he could get a search warrant for Rick Forcier's house based solely on a dog hit, a cadaver dog around the area of his property. And he uses, to back that up, the notion that you can get a search warrant based off of a drug dog hit. What he leaves out is you don't even do the drug dog unless you already have some probable cause. So imagine, for instance, like a package shows up in the post office or whatever. They can't just run the dog out there and search every package, right? The first thing is they need some reason to think that, like it's coming from a place where drugs are common and maybe you can sort of smell something, or it's going to an address that doesn't exist. I mean, you can imagine all the sort of little pieces of information that would indicate to you there might be something wrong with this package. Then you can go ahead and have your dog take a sniff of it and see what the dog sees. So like I said, his interview is interesting. I don't think Aaron should take it down, but I definitely think James Renner is right when it comes to there are some very problematic statements that he makes, some of which probably would meet some definition of defamation or slander. Now, I'll say one thing more on this. There were some people who said that they thought it was significant that Rick Forcier had not brought a lawsuit for defamation. There are all sorts of reasons not to do that. Number one, it's expensive. Number two, you're probably not going to get much in damages. Number three, it opens you up to all sorts of things. Some of you out there who are familiar with the West Memphis Three may know that one of the folks involved in that case, Terry Hobbs, actually brought a defamation claim against one of the Dixie Chicks. I forget the lead singer. I don't know her name. But because he did that, he was subject to deposition. And they actually used that deposition to really dig in to whether or not he was involved in the murder of the West Memphis Three, the children West Memphis Three, not the accused murderers. And that's an interesting case because he lost that basically because he was a public figure at that point and it was a matter of public interest. So a similar case as to what we have here. On the other side of the coin, and I may actually put this on the website, CBS did a documentary series on JonBenet Ramsey. And in the course of that documentary series, they accused Burke Ramsey of killing JonBenet. And there were a number of things they said in that series that were demonstrably false. So Burke Ramsey actually sued CBS. The complaint is great. I mean, you should read the complaint for all sorts of reasons. Number one, those of you who believe that CBS documentary, it does a really good job of laying out all the errors and all the factual mistakes that they make. And it also is sort of a good, not refresher, but a good sort of quick read on how this area of the law works. So if you're interested in this, if you think it's an interesting thing, I'll put that on the website. I'll just find that complaint and put it on the website. You can check it out. So it's an interesting area of the law, but you don't see a whole lot of defamation lawsuits. Okay, so we've talked about grand juries. We've talked about slander. So the last legal nerd thing we want to talk about today is FOIA. FOIA is the Freedom of Information Act. FOIA is a federal law, but every state has, essentially, I assume every state I know of, has some sort of open records law, some sort of sunshine law that allows citizens and reporters and journalists and everybody else to have access to public documents with certain restrictions. Now, interestingly, Alice and I, we're both prosecutors, but we haven't always been prosecutors. In our former life, we actually worked together in a different job, and I was in a position where I was always trying to prevent documents from going out, and Alice was in a position of trying to defend decisions not to produce documents in court. So Alice actually knows a lot about FOIA. So our FOIA expert today, Alice, is going to explain to us how these laws work, and then we're going to talk about what happened in New Hampshire and the Murray case and sort of what we think the state of the law is now.
So before I get started on FOIA, again, this was an area that a lot of you indicated an interest in. So I'm not going to lie, it's a little bit weird, and I'll tell you why. One time when I was getting a call about a FOIA matter, the person on the other line said, it was an attorney as well, and they said, "Do you want to know the first question I ask anyone who deals with FOIA?" And I was really busy that day. I wasn't in the mood for any jokes or limericks, and I was like, "Sure, why not? Tell me." And he said, "I always want to ask, who did you F over to have to do this job?" So, with that said, kind of like Brett said, so the Freedom of Information Act, FOIA, you've probably all heard of, because what it really did in the 1960s was create a right that's enforceable in court. And we say that because what a lot of people may not know is that you don't just have a cause of action whenever you want to sue for something. And before this, before FOIA was enacted, you couldn't just go to court and say, "I'm entitled to these documents." And so Congress actually decided, you know what? We want another branch of government, this is only for the executive branch, to have to turn over documents about, agency records and those sorts of things because we want the agency, the executive branch, to be held accountable for their actions. And one interesting note.
Note that
Exactly,
Congress does not apply it to themselves.
We should note that two other branches of government are not subject to FOIA. Congress, the one who wrote the law, and of course the judiciary. And that actually makes a lot more sense why the judiciary is not subject to FOIA. We can go into that more if any of you have questions. But yes, do note it is only for the executive branch. Now, because federal FOIA is quite well developed, quite well litigated, there are diverging jurisprudences in different districts and different circuits, but for the most part, it's pretty well developed as to how FOIA is interpreted, that most of the states look to federal FOIA when interpreting their own state FOIA laws. And I say FOIA laws, it's called something else in each state, but generally when I say FOIA, I'm just talking about these sunshine laws. So generally, FOIA says, hey, public, anyone can ask for records from, in federal, the executive branch, in other states, whatever agency is subject to the FOIA. But Congress did recognize that there are some documents that really can't go out based on, intergovernment workings. For the government to properly work, some documents have to be able to be exempt from FOIA. So federal FOIA has 9 exemptions. I'm not going to read all of them to you. You can look it up if you'd like. It's codified under 5 USC section 552. And just to give you an idea, things that are exempt from FOIA are like classified national defense, foreign relations information. You can imagine why that would be important to withhold from the public in our foreign dealings. Trade secrets, confidential business information. What's important in the Maura Murray case is Exemption 7, which is records or information compiled for law enforcement purposes. So it gets further broken down, but it's generally procedures and techniques of the police, and also if the release of that law enforcement information will endanger lives and safety. And again, you can imagine why that's important. We've already talked about how police need to hold back evidence on ongoing investigations so as not to give away too much information and hamper their investigation. This is what Exemption 7 of FOIA is getting to as well. And then this is just for completeness purposes. Those were exemptions, which just based on word usage means these documents are subject to FOIA, but they are exempted. There are also exclusions to FOIA, meaning FOIA does not apply to them at all, so you don't have to justify withholding them. And they typically have to do with like counterintelligence, like FBI counterintelligence, and also criminal proceedings. But that goes really too much into the weeds. That's just for your knowledge that there are things that FOIA just doesn't apply to. So, I joked about the person saying, who did I, anger in order to have to deal with FOIA. The thing is, FOIA really is so interesting because this is how a lot of people try to get around discovery. In discovery, you don't necessarily get access to everything you want. It has to be relevant for your case. FOIA kind of allows you to ask for any documents, no matter who you are, if it doesn't fall within one of these exemptions or exclusions. So it's no surprise that people in the Maura Murray community, as well as the family, have submitted records requests to the New Hampshire Police Department. And Fred, Maura's dad, did. I think the family has submitted a number of FOIA requests over the years, but a number of these FOIA requests, and I don't know exactly how many, for the most part, they've all been denied by police. And the police have mostly noted that it's because the case is ongoing, that it would hinder their investigation if these records were released. So I don't think the Murray family has received much information, if at all. I should note one other thing. I said that anyone can submit a records request. You don't have to have a personal tie to the case. So the Murray family can submit a request, but so can any of these podcasters. Now, once an agency decides to release information, that information is considered public. everyone can have access to it, not just the requester. And so these types of decisions are going through, these types of considerations are going through the agency's minds when they are deciding whether to release. Because once you release something, it's for the world to see. So let me take you to the case that the Murrays brought. So after they were denied all these FOIA requests from the New Hampshire Police Department, they decided to appeal and go to the district court first. And this actually went all the way up to the New Hampshire Supreme Court in, I think, 2005 or 2006. And the result from the Supreme Court case resulted in something called the Murray exception. But before I jump all the way to the end, let me start at the beginning. Soon after Maura Murray vanished, Fred started filing these state right-to-know law requests. He was denied, and they said, this is an unwarranted invasion of privacy, and these records are investigatory in nature. So in 2005, Fred goes to court, and the trial level actually finds in favor of the police department, and they cite investigatory nature of the documents would interfere with law enforcement proceedings. And that's all fine, but they go one step further. Now, typically, because you can see how one-sided it would be. One side is saying, you can't see these documents and we're not going to tell you why. The court can actually say, wait a second, we need a little bit more information to decide whether to find in favor of you, state. We can ask that the court review these documents in camera, meaning only the judge's eyes see these documents, and the court can make a decision whether, in fact, these documents are investigatory in nature. Or there's something else called a Vaughan Index. The court can order the agency that wants to withhold documents to create and file something called a Vaughan Index, which is essentially just a table of contents that describes in some level of detail what is being withheld. And the court in this case, I think the Murrays did ask for a Vaughan Index or a camera review, and the trial court explicitly denied both of those options before finding for the court. Just in my experience, that's a little bit surprising, especially for a pretty high-profile case. Typically, if the court's going to find against the requester, they'll at least take a couple steps and say, okay, file the Vaughan Index, file these documents in camera, and there's just more information that way to make this decision. So this gets appealed to the New Hampshire Supreme Court, and the New Hampshire Supreme Court says something that is true of all of these kind of right-to-know, sunshine, FOIA laws, and it's that the purpose of these types of laws is to allow the greatest possible public access to records of public bodies and their accountability to the people. And they say, and I quote, and we see this language in most FOIA cases, quote, "We construe provisions favoring disclosure broadly while construing exemptions narrowly." So if a public entity is trying to avoid disclosure, then that entity bears the heavy burden to justify non-disclosure. Otherwise, of course, these sorts of sunshine laws have no teeth. Now, the New Hampshire Supreme Court noted that the New Hampshire right-to-know law doesn't address police investigation files specifically. So this court looks to the federal FOIA to evaluate requests of police investigative files, and specifically the Exemption 7 that I noted earlier. And Exemption 7 actually lays out 6 reasons for withholding, but the first one is what's relevant here, and that is you can withhold police files if you reasonably expect them to interfere with police proceedings. So there's some burden shifting that goes on. First, that public entity needs to show that the documents are 1, investigatory in nature, and 2, compiled for law enforcement purposes. In this case, I don't think there was any sort of argument about that. But once there's that initial showing, then it's still the public entity that has to show that disclosure of these documents would interfere with those proceedings. So the court goes into, how can a state meet that burden to show that it would interfere with proceedings? So this is speculative in nature. You don't know what's going to happen. And the court says you don't have to go document by document, and the descriptions can be somewhat generic, but they have to be specific enough to permit the court to understand how each category of documents, if disclosed, could interfere with the investigation. In this particular case, the types of explanations the state gave were really too vague for the Supreme Court's, from their opinion. I think they said things like correspondence, maps and diagrams, but it didn't say, what about that correspondence and what about those maps and diagrams could interfere with, could allow interference with police proceedings. And they say specifically that these descriptions need to be distinct enough to allow meaningful judicial review, yet not so distinct as to reveal the nature and scope of the investigation. I have to laugh a little there because this is so like the law, where it's saying it's very difficult to interpret what that means. And I mean, be specific, but not too specific.
This is why lawyers have jobs.
I was going to say, that's why we have jobs, apparently. So how you can meet that typically from the state, the Supreme Court says, is you have affidavits that explain why the disclosure would affect or interfere with their investigation, with their proceedings. Now, this is a lot of words and it could be confusing, but ultimately what the New Hampshire Supreme Court did was they said, state, you haven't met your burden, so we're going to vacate the district court's decision. Now, you may think that means the Murrays win, but not really, because they're not actually talking about the request, which is frustrating for litigants, because you would think, oh, I get to appeal this, and the Supreme Court's going to say, so release those documents. But that's not what happens here. They say, you didn't do enough. Potentially you could do enough, so instead of us deciding on the request, go back down to the trial court. State, you get a second bite of the apple, try and make your case, and ultimately I believe what happened is that they did not end up releasing really any documents. So even though the Murrays they won at the New Hampshire Supreme Court, they didn't really win. And that is a frustrating thing, I know, for litigants.
Yeah, and there's a lesson about the law in this. I mean, this is one reason I hate stories, like news stories about the law, because they're always wrong. Like the headlines will always say something dramatic and it's almost never true. And it's one reason these kind of cases are so tough on litigants, because the Murrays thought, wow, we've won, the Supreme Court ruled in our favor. But if you're going to win a case, you really need to win at the trial level, because the trial level, that's the level that cares about you. Generally speaking, the appeals are all about everybody, right? So it's all about the standard and the rule of law and the burden, right? So they weren't so interested in whether or not the Murrays were going to get information. They were interested in making sure that the trial court was applying the proper standard. So they just said, hey, go apply the standard. You didn't do it the first time. And the trial court basically said, oh, sorry about that, and then came to the exact same conclusion. They just explained it better. And that happens so often.
And what's interesting? Essentially, if you have a well-written appellate opinion in this manner, they're laying out for the state how to make their case at the trial level. They're basically giving them a script of how to do it. They're saying, hey, don't just say correspondence, say correspondence that goes to communications with the prosecution, and that's enough. And so, it's important for purposes of clarifying the standard for all future cases so that there's not continued litigation over the same thing, but frustrating for individual litigants.
And FOIA is one of those areas of the law that can be very frustrating for people. And you understand why some people think that FOIA is really just a Congress's, what's the word I'm looking for? It's like
revenge.
Revenge is a good word. No, it's just like a publicity stunt, right? Like, it's like, look at us, we're going to be so transparent, and the presumption is in favor of release, right? But in reality, all you get from it is trash, usually. The documents you actually want are going to be covered up by one of these exceptions. I know I've heard people say that FOIA offices are the place where sunshine goes to die, which is, wasn't the point of the laws, but that's just how they kind of work out. And I think the Murrays have run into that. I mean, they have a case that now is 16 years old, and yet they're still being told we can't release any information to you because it might affect our investigation. And there's this pernicious incentive where the Murrays, because they really care about Maura and they're really pushing and they're really fighting and they're really, shaming the police to continue their investigation, because they're doing that, the investigation continues, and thus they don't get documents that they might get if nobody had cared about this case for 15 years. One thing we're going to put on the website, the case went back down, and there were some hearings about this, and there's actually some really good stuff in this hearing, sort of going through what Alice was talking about. A.G. Strelzen, who is he's not the AG, but he's an assistant AG who's in charge of this case. He testified, and they talked a little bit about the open records laws and why they're the way they are. But there's a quote that people repeat a lot about this that I really think people have invested way more meaning into than they should, and that's about, he says there's a 75% chance that this investigation is going to lead somewhere. Which leads a lot of people to think, oh, see, they're so close. They know there's a crime. So here's the question, and here's what he said. You indicated in responding to Attorney Irvin that you could give him a percentage that you have in your mind of likelihood. What is that percentage regarding whether the likelihood of this results in a criminal case? And he said, I'd say it's probably 75%. I don't know what that means.
Yeah.
It's not...
And what do those numbers mean?
Yeah, there's a joke about how if somebody asks you what the probability of something is, you just say 60%, because if you're right, it makes you look smart because it seemed like a really close thing, but you got it right. And if you're wrong, you're like, well, it was only 60%. And I feel like that's kind of this here. It's not likelihood of a conviction or likelihood of an arrest. It's just likelihood this results in a criminal case. And he just pulls this number out of the air. So I don't know how significant that is. I don't know how much that affected the judge. I do think, and I'm not giving any legal advice here, but I do think if I was going to bring another case, if I were the Murrays and I was going to bring another case about this, I would use this against them. You said 75% 10 years ago or whatever, more than that. Can't be that high now. And like Alice said, this is something you consider when you think about the value of these documents. What is the real chance that you're going to have some sort of interference with criminal proceedings? And the lower that number goes, the more likely I would think that you could succeed. The problem really is, this is like the core of the exemption, right? This is
the exemption that is most used and actually probably most serious, other than say counterterrorism.
Yeah.
But
because judges in the judicial system, they just look at criminal investigations and they think, yeah, we can't let that out for all the reasons that we've talked about on this podcast. The holdback evidence and being able to differentiate between people who really did it and didn't, and excluding people and all that stuff, right?
Not letting names out that are still in the, who are not suspects, but are tied to the case, not wanting, privacy.
Protecting people who were suspects but have been cleared, right? You just don't want to put their name out there if you don't have to. There's all sorts of reasons that you do this. So it's going to be a fight. I think really what the Murrays need is some cooperation. I think that's the best way that this can be resolved. I don't anticipate a judge is going to order the police to hand over their investigative file. Now, would they be able to get some documents that maybe they couldn't get 15 years ago? Maybe. But it is always going to be an uphill fight when you're dealing with FOIA.
There's a lot more to be said there, but we'll leave. This is probably the longest discussion of FOIA any podcast has ever had.
I can feel people canceling their subscriptions even as we talk.
I know. So we'll stop there for now. But, if you have specific questions or anything has been not clear about any of the topics we've discussed, let us know. And we love having these side conversations with a lot of you. It's really enlightening to us. We love it. We really do read all of your messages and all your emails. So keep them coming. We really appreciate it.
We try to respond to most of them. If you email us or send us a message on Twitter or whatever, you're probably going to get a response. So, and we enjoy that. We enjoy talking to you guys. We enjoy your theories. People have sent us every theory under the sun. Guy sent us 23, I think, reasons that the killer was actually Butch Atwood yesterday. I don't think it was Butch Atwood, but he had 23 reasons, so you can check that out. But, just leaving this case behind for now, for hopefully a long time. I mean, it's interesting. It's addictive. You fall down the rabbit hole on this case. Alice and I have talked about that. We tried to stay away from the drama. We tried to stay away from the conspiracy theories and really just talk about the facts as best we could. That's almost impossible in this case. I think my parting thought on this case, and I really think this is true, I think if you knew everything that happened between that Thursday night and the morning after Maura disappeared, I just don't think it would be kind of ho-hum. I don't think you'd be like, oh, I guess that's what happened. I think there's some weirdness about this case. There really is. And I think there's a lot of things we don't know. And I think there's a lot of things that we probably never will know. I still believe that if you're ever going to find Maura, it's going to take all these people with all this passion, putting aside their differences and trying to work together on it. I mean, I think that's the only way you're going to come to any kind of truth here. But there is a reason so many people are passionate about this case.
Amen to that.
Well, Alice, it's been fun. I hope everybody's enjoyed our very extended investigation into Maura Murray. It seems like things are just getting hotter every day in this case. So who knows? Maybe we'll do another follow-up episode in a few years. But, we've done these 2 follow-ups. I'm sure you guys have comments, thoughts, questions. You know how to find us at ProsecutorsPod for Twitter, Instagram, Facebook. ProsecutorsPodcast.com is the website. And then you can email us, prosecutorspod@gmail.com. Like Alice said, we love hearing from you, and we will do our best to respond to you. It's a wild ride in Maura Murray world, so you guys enjoy it. But next week, we will be back, and we'll be back with a new case, new questions, and hopefully new answers. But until then, I'm Brett.
And I'm Alice.
And we are the prosecutors. I'm like chewing on this Jolly Rancher. I feel like I should finish it. Yeah, I do. I love Jolly Ranchers. I mean, I'm more of a green apple guy. I actually don't know. I'm not an expert in raspberries. Well, I just don't know. This is a mystery. Like green, because you want it to be blue. You got cherry and watermelon already. I feel like you're overthinking this. I mean, no offense. I'm not trying to be offensive. This whole thing.
Well, I was, but we talked about blue Jolly Ranchers for like 20 minutes. Sum up our 20-minute conversation about blue raspberry. I don't think it really exists, and it's just weird to me that blue raspberry Jolly Rancher is a thing. Why not just red raspberry Jolly Rancher or blue artificial coloring raspberry?